welcome to this edition of John's Rants. I'm John Giardinelli. I'm the association's counsel. I'm with the law firm of Tyler and Birch. And we're here today to talk about something a little out of the ordinary. Normally, I talk about issues that are relevant to your daily practice. But today, I want to go into some really big ticket issues because some things are happening that you may need to prepare for, think about, talk to your friends about, and generally understand. So we're going to talk about the current status of the MLS and the current status of some issues before the multiple listing service and NAR. As most of you know, NAR has a group of rules that basically require that whenever you enter a listing into the multiple listing service, that you make a non-contingent unilateral offer of compensation to the other participants and subscribers of not only CRMLS, but also any reciprocal multiple listing services such as CLAW that participate with a CRMLS. The only basic exception is, of course, the issues of short sale offers where a bank may reduce the requirement or the amount of commission that you are to receive. There are claims out there, although I don't personally agree with them. I think that they're wrong, but there are substantial claims that by requiring an offer of compensation, the National Association of Realtors and the local associations artificially and illegally increase costs to the sellers. And the reason for that is I place my listing in the MLS. I have signed an agreement with my listing agent, and my listing agent is charging me, pick a number, it doesn't matter, 5%. They then will put something in the multiple listing service, offering some portion of that, usually up to 1/2, to a buyer's agent who brings in a qualified, ready, willing, and able buyer. In other words, has become the procuring cause of that. Now, there's also some rules that say if I double end the deal, then I might reduce my commission since there's not as much work as there is in cooperating with another agent. And so those are the basic rules. California has a civil code that has made that statutory, and that's what we have. The MLS cannot require a minimum amount of compensation. That would be considered clearly to be antitrust. But what is happening is in certain litigation, all in the Midwest, sellers are claiming that by requiring the listing broker to offer compensation, it is artificially and illegally increasing costs to the seller, because the seller is then required to pay not only for the services of his or her own agent, but also having to pay for the services of the buyer's agent, who then negotiates against the seller, works against the seller in terms of repair issues and other issues, and generally is not on the seller's side, and therefore is an adversary. There's lots of reasons why that's not correct, but the litigation is moving on, and it's already having some impact. For example, the Department of Justice sort of created a situation where they were looking into these cases themselves, and as a result, NAR recently changed some rules. For example, you can no longer advertise on the buyer's side that your services are free unless they truly are free. In other words, if you are getting a commission from the seller's side in the typical fashion, your services may be quote unquote free to the buyer, but they're still not free because the buyer is paying your commission through the cost of the house, at least in theory. The buyer side commissions are now more transparent. Buyers now know what their buyers agents are being paid. And of course, you can no longer search for housing by compensation only. Additionally, there have been rules put in place for coming soon signs, clear cooperation. There are issues surrounding the privacy of clients, and of course, lots and lots of issues relating to other types of business models, such as virtual office websites, IDX exchanges, and the like. As I mentioned, there's a lot of litigation pending right now and a lot of government intrusion into the MLS situation. There are challenges, legal challenges to the clear cooperation policies. Those are ongoing in California. There was a buyer antitrust lawsuit, very similar in nature to the seller antitrust lawsuit, claiming that buyers are also damaged because as a buyer, I am paying through the cost of my house the seller's commission, since the seller isn't writing a separate retainer check for their listing agent. Obviously, there are the seller antitrust lawsuits. The Department of Justice has been investigating and has filed an action against NAR. That case was tentatively settled, but the settlement is not being honored by the Department of Justice when the administration changed. And now there's litigation pending over whether the settlement is enforceable or not. And then the Federal Trade Commission has also entered into the fray and may be passing some rules that affect the way that multiple listing services do business. There have been two recent decisions that are very, very important. The Leader case. This was the lawsuit filed by the buyers claiming that they should be certified as a class and they should be allowed to sue NAR on the theory that the fact that the buyer is being required to pay a portion of the seller's commission through the increased cost of the house is an antitrust violation. In April, that case was dismissed without prejudice. What that means is they are giving the buyers an opportunity to amend their complaint to add in facts that would give rise to a claim that could be honored by the court. The court did indicate, however, that she did not feel that the buyers were going to be able to do that. Now, I suspect one of two things will happen. Either they will attempt to amend the complaint, in which case there will be another motion to dismiss, or they will simply appeal the decision of the judge. In reading that case, however, it became clear to me that the judge wasn't saying there's not a problem. They were just saying that because the sellers have filed a similar type of a lawsuit, that a lot of these issues will be resolved on the seller litigation. Now, the other case is very problematic. It's a Missouri federal case filed in that district, and it basically is the case that says that sellers have been damaged because sellers are required to pay more in the way of commission because they have to pay through the offer of compensation the buyer's side. It misses a couple of important issues, however. It misses the fact that even when the listing agent double ends a deal, there's very little in the way of discount, sometimes no more than even 1%, so that a 5% commission becomes a 4.5% or a 4% commission, called a dual variable rate. There's also the fact that a lot of agents don't offer a substantial amount of compensation. They just simply want to get interest and hopefully find someone that they can negotiate a commission with. So in that case, however, what the court did is, in a very exhausting 41-page decision, they went through all of the reasons why the case was ripe for class certification. What that means is that all of the sellers in the district that this case has been filed in, all the way back to April of 2015, are going to be part of a class. And that represents how many tens of thousands of sellers, how much commission. It's going to be a very, very complicated, expensive, long drawn out lawsuit. But it has resulted in some changes being made, because what's at stake? Well, what's at stake are damages, billions of dollars in damages, attorney's fees, millions and millions of dollars in attorney's fees, and of course, a potential change to the compensation model. There is a similar case pending in Illinois, and the facts are very, very similar. The allegations are very, very similar. That matter is still pending on procedural grounds. So there's a lot at stake, but not the least of which is the model that's been followed by organized real estate and how commissions are shared, offered, and paid over the last several decades. So lots being considered right now by organized real estate. And I wanted to bring some of that to your attention. One of the things that's being considered by a California task force is that a determination may be made down the line that buyer-broker agreements will no longer be voluntary or negotiable, that they will be mandatory. That at some juncture, when you're representing a buyer, either before you start showing them property or before you write up an offer, which is similar to the provision for a written agreement with sellers, you will have to have some form of a buyer-broker representation agreement. That is not out of the realm of possibility that they may actually seek legislation and or a rule that would be approved by NAR that in California, the buyer-broker representation agreements would be mandatory. Another thing that's happening right now and probably will occur in December of 2022 is that they will take the 3 current buyer-broker representation agreements, which are voluntary, and convert them into one overarching buyer-broker representation with boxes to check off as to whether there's compensation, how much, whether it's an exclusive buyer side representation, or simply if you represent a buyer, this is what you'll be paid minimally, with credit being given to the buyer for whatever the seller side pays you. And all of that's being discussed right now. And I suspect that sometime in 2022, we'll see some new forms replace the current forms that are in existence. And we might even see a potential for some legislation that could be suggested. They're also looking at all of the code of ethics and other rules regarding negotiating commission. Some of you may recall that several years ago, it occurred to me, and I said, it was live, so very few of you were probably there, if any, that I thought that there may be a change in the way brokers get paid. Right now, you get paid on what is a contingent model. If you close the transaction, if you bring in a buyer, you'll get some money once the transaction concludes under most situations. In the future, while that may still be a basic model, you may see more brokers charging for their time, either by the hour or on a flat fee basis or in some other manner. And of course, the rules for how the two brokerages negotiate the payment of a commission may be different. We will probably see some form of a buyer advisory where the buyer will be given a standard form advisory, probably at a very early stage in the representation or prior to an offer being made, that advises them of all of their rights and how those rights may be protected. they're reconsidering the procuring cause guidelines. A couple of rants ago, we covered the procuring cause guidelines. This is a situation where the buyer broker is in a disagreement with either the listing broker or another buyer's agent or both over who actually procured the buyer. And there are some written guidelines that the hearing panels will follow as to how that is to be done. And those guidelines are under review presently to see if all of these issues that are being discussed at every level, and I'm only touching the iceberg on all of the litigation, that maybe they need to reconsider some of those procuring cause guidelines. And of course, additionally, they're looking at reviews of the code of ethics to see if there needs to be any change in the code of ethics. So those issues are also being addressed. And of course, all of this is being done with some very fine groups that have been put together in order to see if there's some things that need to be done to modernize the way that brokers earn compensation. Of course, some of the problems may be that if we make it too difficult for buyer brokers to be in business, that buyers may find it difficult to get individualized representation. Other kinds of issues could crop up. There may need to be some changes in California law regarding dual agency and all of those kinds of things. So there's a lot of issues, but the one thing that's clear is that agreements between buyers and their agents are usually not documented, which is a mistake. According to recent statistics, and of course these statistics can be skewed any way you wish, but clearly less than half of all buyers have a written agreement with their agents. And so it's pretty clear that this is an underutilized protection for both the buyer and the broker. How commissions are paid may someday be modified. So again, there's going to be a lot of potential impacts to some of this. Obviously, will buyer brokers continue to be utilized in the same manner that they're used now? Personally, I believe there's a lot of risk about being a dual agent. So by pushing buyers into a dual agent relationship could create some problems. Secondarily, if the buyer is going to have to retain their own agent at their own cost, how's that going to look? Will lenders allow that to be financed into the purchase price? Will there be any real difference in what people pay for housing? What happens in markets like the one that you are presently in, where it's clearly a seller's market? Are buyers going to be unrepresented? What about people that can't afford to hire their own agent? How's that going to be financed, and how's that going to look? Again, one of the key questions in my mind about all this is anybody taking into account the fact that it's not necessarily in the consumer's best interest to have a dual agent relationship, that it's far better in most situations to have your own agent representing your own interest. Most states now have moved into that type of situation, even in states that allow the same office to represent both the seller and the buyer. They require that different agents within the office handle those situations. Will these rules even help reduce the cost? And if so, how? There have been some poorly thought through comparisons to Europe and to Australia, but the reality is it's a far different market. We have far different rules, particularly in California. California is a heavily litigious state, and so those issues are very, very important. What about the obligations, the duties, the legal responsibilities of brokers? How are they going to be handled in situations where the way people are paid is different, and therefore the way they approach representation is different. And then, of course, what kind of federal, state legislation, administrative rulings, Department of Real Estate issues may crop up. So these are very, very, very important issues. I suspect we'll start seeing some of these issues resolved by the end of this year. We'll see what's happening with the Chicago antitrust case. We'll see what's happening with the Missouri antitrust case. We'll probably see what happens after November, if there are changes in Congress and how that might affect some things down the road, with a different type of a mix of a two-party system. We will see, of course, what CAR thinks is best for its members and for the consuming public. So keep your eyes peeled. Being a realtor today is critical because you have some incredible leaders that are wrestling with these issues, and hopefully they will make the right decision. So until our next rant, I appreciate your time. What we're going to do with the next rant is something I've never done before. Through all the training that I do and through calls that I get, cases that I handle, consultations I get involved with, I have hundreds and hundreds of questions from the real estate community as well as from lawyers and others. What I'm going to do is I'm going to go through all those questions. I'm going to come up with 10 or 15 questions that are asked all the time regarding the RPA, regarding risk management, regarding whatever issues I see, and I'm going to take each one of those questions and answer them. If you have questions, send them to Lori Smith at the board, and she'll make sure that I get them before the next rant. So until then, this is John Giardinelli of John's Rants, and I'm signing off, and thank you very much for listening and watching this presentation.